What's up, everybody? Welcome back into an episode of The Lawyer You Know. And today we're jumping back into Donna Adelson's case. We're a little over a week before her trial begins. I'm going to give a little bit of an overview for people that are new to this case and the madness that is included in this entire saga and how we got here today. And we're going to go through the entire pre-trial hearing. This is the final hearing before trial where we hear the final couple defense motions of some major pieces of evidence that they want the judge to cut out of the trial, which would be very different than any other trial in this series of trials in this case. Plus, we get to hear about when jury selection is, how long they think the trial is going to go, and get everything set and ready for this trial to start on August 19th. Let's get to it. I froze there for a second because I was like, what is this? This looks different. It is our new intro. So hopefully you guys enjoyed that. We are coming up on the trial for Donna Adelson. And this is a case that centers around one of my former professors while I was at Florida State University College of Law, Dan Markell. Brilliant guy, was on to bigger and better things probably, even though he was at the Harvard of the South there for Florida State. He was known as a brilliant legal mind, was killed in his driveway in Tallahassee suburbia. Come to find out, he was in a very nasty divorce with his now ex-wife, Wendy Adelson, and they had 2 children, and it was a vicious custody battle. Her family, who was a wealthy dental family in South Florida, the Adelsons, were very involved in the family law case, and it was very, very ugly. And when Dan lost his life, a lot of people initially thought the Adelsons had something to do with it. But it took a very, very long time. And eventually, law enforcement was able to put together, connecting all the cameras from Tallahassee to South Florida, that there were these 2 potential gang members that came up and did the deed in Dan Markell's driveway in broad daylight, literally. And they pieced together some eyewitness statements about they think the car is this kind of car. They were able to take a timeline, build it out, and eventually, one by one, go from the person that had the gun in his hand, the driver, the connector between the gang members and the Adelson family, and then Charlie Adelson, and now Donna Adelson. Okay. And how did they connect the Adelsons to the shooter? Well, there was a woman named Catherine McBanawa, who was a former girlfriend of Charlie Adelson, who is Dan Markell, the victim's brother-in-law. And his ex-girlfriend also had an ex that happened to be one of the gang members that showed up to Dan Markell's house. She was the connecting piece. Law enforcement was able to do a bump, involve the FBI, get recorded tapes, code language, code word. And Charlie Adelson in his trial told the story that they were blackmailed. The Adelson family was blackmailed, and that's why they paid money to these people. And it was all these people. It was their idea. They did this to Dan Markell to try to get money from the Adelson family. The jury did not buy that, and they convicted Charlie Adelson. It is now up on appeal. He has one of the best appellate attorneys in Florida, Michael Ufferman. I had him on the show a while back. If you guys want to check that out and see what he says about appeals. Yes, so many wild turns this case. I don't know how we can pick what the craziest part is, potential juror. But yes, one of the absolutely wild parts of this is Katie was allegedly offered complete immunity if she would flip on the Adelsons. She said no, went to trial once. It was a hung jury. Then she was eventually convicted. Then she came out and testified against Charlie. Will there be another deal there? Were there deals offered to Donna Adelson? That has been reported. That has been shut down. Then it's been kind of talked about again. Was it a hard offer or not? Was it a formal offer or informal offer? Who's next? Somebody's saying, will Harvey be arrested? That is Wendy Adelson's dad, Dan Markell's father-in-law. Will Wendy Adelson? That's what everybody's been waiting on. She has been testifying in all these cases, but she hasn't been indicted. The actual ex-wife and mother of his children. So there's just so many things going on in this case. And we have the final pretrial hearing before Donna Adelson goes to trial. And keep an eye out talking about those deals and so many things about boots on the ground for our podcast on Monday. If you're following this trial, make sure you hit that like button and are subscribed to our page, and make sure you don't miss our podcast on Monday. So that's kind of the overview, and I wanted to give anybody new kind of what's going on. Also, I will say, do this to your ears. Get your ears all cleared out because we're back to some very horrible court audio. I checked 5 different channels None of them are great. So we're just going to do the best we can. We've got the closed caption on. I will repeat a lot of what's being said in here and break down what's important. Yes, Dan was one of my professors. I took one of his seminars in criminal law. He gave a bunch of seminars in criminal law that you go in there. He was not my criminal law professor, but I did go to his seminars on criminal law, learned a ton from him. And I also watched a bunch of his seminars and talked to him in the hallways at Florida State as one of my professors there. And he was not the biggest personality, most boisterous guy in the world, but obviously very, very brilliant. Not what I'd call a trial lawyer, but an academic. Somebody else. Man, there was something else I wanted to. Oh, didn't Wendy get a deal? So Wendy keeps testifying, but she basically is testifying in the manner that she's forced to testify. She would plead the fifth, but they say, we're not going to prosecute you for anything that you say. So you can't plead the fifth. So you got to testify. So if they ever indict her in the future, they can't use anything that she's doing when she's being forced to testify. We break that down more in the podcast on Monday. So you'll want to stick around for that from a guy who's given immunity deals and knows how that works. All right. Get ready for this audio. It's not great, but we are going to get through it together.
I believe we have several defense motions to address. Ms. Kappelman, the state has not filed any additional motions in limine that have not already been addressed by the court.
That's correct, Your Honor.
All right. Let's start then with the motion in limine concerning the court file relating to the dissolution of marriage.
This might be the biggest piece of evidence they're trying to keep out. They're trying to keep out a bunch of important things, but the family law court file, if you don't remember from Charlie's trial, the family law court file, when we were listening to that together and they were explaining the emails going back and forth, what the Adelsons were doing, what Dan Markel was doing, it was a very ugly family law battle, which unfortunately, I'll just say in Florida and probably across the country, is not uncommon for it to get really nasty, really dirty, the things people say about each other. But whose name was all over it? Who had motions written specifically requesting action against her? Who was saying some of the most vile things about Dan Markel and about the entire process? It was Donna Adelson, who is the defendant in this trial. I remember watching Charlie's trial and thinking, man, Donna looks even worse than Charlie. Charlie's not really involved in any of this. Now, he was obviously an intricate part once you get into the entire conspiracy, but Donna Adelson's name was all over it. Yes, this judge is one of my favorite ones to watch. Very decisive, kind of funny, very flat affect and dry. I like him.
Mr. Zellman?
Thank you, Your Honor. Your Honor, as is my custom, I lay it out in motion. It's our position that the vast majority of the court file, even with the court taking judicial notice, is inadmissible. It's irrelevant. Paragraph 7 of my motion provides a somewhat comprehensive list of the items that are in there that have no bearing, have no relevance, or not material in any way to this case. And so we're asking that, aside from very limited number of items that the state can establish has relevance and is not barred by hearsay, we're asking the court exclude that file.
Ms. Kappelman, which
They want the entire family law file out. Can't use anything. So he asks the prosecutor, who I also really like. She's a bulldog. I really like her as a prosecutor, and you'll hear her personality come out in this hearing. He's like, okay, Ms. Koppelman, Georgia Koppelman, what parts of the file do you want to use?
parts of this file is the state seeking to admit as a part of its case in chief?
The entirety.
She, without hesitation, she's like, all of it, Judge. And let's hear her reasoning why.
Right. As to the items that deal with, as identified in paragraph 7 of the motion, what exactly would be the relevance first? And what is your argument as to hearsay?
Well, relevance, Judge, it goes to the motive, the level of intensity of this litigation, the volume of the paperwork suggests that it was very litigious and went on for some time. The words that are used are strong, even hateful, and this was a cause that was adopted by the defendant, as the emails evidence will show. So it's important for the jury to understand the foundation of this motive is this litigation that began with the divorce, continued beyond the divorce with the child custody issues that developed later.
All right. So in part, the volume of what occurred over the divorce proceedings, you want the jury to recognize this goes to motive in some way.
Yes, Your Honor. In reference to hearsay, the items are not being offered for the truth of the matter asserted. There obviously was a litigious divorce, but it's being offered to show the effect on Ms. Adelson. These items were shared with her. The evidence intends to show she was very involved in the pleadings. She was sent the pleadings and offered detailed responses for how Mrs. Wendy Adelson should respond to the pleadings. So it's very bound up in the state's theory of the motive for the case.
All right. Mr. Zellman, as to your client,
By the way, I'm not familiar. I know some background about these defense attorneys, not really familiar with them, have not seen them in action, so I don't have any opinions on them at this point. But again, the person I bring on the podcast on Monday knows them, knows exactly how they work, what their backgrounds are, so we'll dig more into that. So while we say we like the prosecutor, we like the judge, in this case, prosecutors both, we'll still TBD on the defense attorneys.
emails to her daughter as this litigation is going on, are these contested in any way?
With respect to the initial dissolution proceeding, no. However, in reviewing the emails, the post-dissolution matters that were filed by Mr. Markell, there's no evidence in those emails that those pleadings were shared with Mrs. Adelson. And so certainly, if the state's theory is that it goes to the motive, and that's the way of getting around hearsay, they have to establish that the pleadings were sent to her. My review of the emails show that did not happen. So they can't go to show my client's motive if she didn't receive them.
Somehow, if the audio wasn't bad enough, it gets even worse here now. Peter, why are most DAs female? I don't think that that's true, that most DAs are female, but maybe you guys can tell me. I have not noticed that. I'm not saying it's not true like you were lying. I'm just saying I haven't noticed that. And I see some mixed feelings about Georgia Koppelman in the chat, which I think is interesting. Tell me what you like, what you don't like about her demeanor and the way that she practices. We've seen her a lot here on this channel. Peter, on the road to a concert, had to watch. That's awesome. Will they bring Charlie out of jail to testify? That's a great question, Randy. And guess what? We are going to get the answer. Actually, we're going to get enough of an answer to that where I feel confident answering your question eventually when we get there in this hearing. Michelle, thank you for gifting 5 Lawyer You Know memberships.
All right. As to any pleadings that correspond with emails or communications that were made by the defendant and otherwise demonstrate her role in or some part in the divorce case, as to those, I'm going to rule they are admissible. The pleadings
So anything that has to do with Don Adelson in the divorce case, and I'm repeating it because the audio sucks. Anything that has Don Adelson on it, or that she's involved, obviously, or that we know she saw it, that's going to be admissible. That's enough. That's all the bad stuff. She was involved in all the bad stuff. So whatever she didn't know about, of course, that's not going to come in. They're not going to be able to use that against her, but that's an important ruling for the prosecution. Not a surprise. This judge, I will tell you, has been very consistent in his rulings case to case for what he's been on. He hasn't been the judge on every case. But everything that he has kind of decided in the past, he's stuck with. He's really thought about it, and he's decisive and confident in his decisions.
themselves, if they're being offered not for the truth of the matter asserted, but to otherwise demonstrate motive or intent, those are admissible. However, Ms. Kappelman, as to the bulk of the file itself, I do believe the defense is raising a clear point on this. Absent a connection or a nexus between the defendant and specific aspects of the divorce file, what is your argument concerning it?
I mean, there are pleadings in there that are not necessary to show the motive, but I did offer the exhibit itself in its entirety to demonstrate the bulk. If Your Honor is not inclined to allow those pieces of paper that cannot be directly connected to the defendant, may I be permitted to show the exhibit as a demonstrative to the witness to verify that that is the entirety of the divorce file?
It is permitted as a demonstrative. You may also ask questions that.
So she's like, I didn't want to use every piece of paper in the file, but I did want to show how huge it is, because when we talk about a litigious divorce or an angry divorce, everybody's like, yeah, every divorce is like that. They're like, no, this one's different. This was between two brilliant lawyers. Wendy Adelson, also a brilliant lawyer, just like Dan Markell. So when you're dealing with that and you got money kind of on both sides, and it's like, this was kind of a one-of-a-kind nasty divorce, and I want to show just how big the file is, even if I don't use every piece of paper. The judge says, okay, fine, it can be used as a demonstrative, but the papers, you got to show a connection in order to use the papers.
Generally deal with the amount of filings and also the volume of the case, but ultimately as to responses for production or mediator notices, I'm inclined to agree with the defense as to that point. If there's not either a relevant connection or a nexus between the defendant's actions and then what occurred in the dissolution of marriage case, all of it does not come in as substantive evidence. But I do want to make clear on this point, Mr. Zellman, as to what the witnesses will testify to, and none of us will know this until the evidence actually begins. This file can be used for purposes of impeachment, and it can also be used for purposes of rebuttal. Depending on what the witnesses say, what might be not a part of the state's case in chief may still be available to them through other means that are permitted by the rules of evidence. Is everyone clear on those?
Yes, sir.
Yes, Your Honor.
let's move on to the motion of limine concerning the testimony of Sarah Youssef. Mr. Zellman,
Again, Your Honor, we stand on the motion.
Ms. Kaplan, response.
I would just ask Your Honor to reserve on her. The state has no intention of calling her, so I don't think, unless that changes, that there's any reason to address her testimony at this time.
And there's going to be a couple that they just flat out agree on, and they're like, yeah, no reason to even go through this. So there's not a lot of analysis there, and we'll just kind of keep it moving.
Well, then I assume you are going to leave Ms. Youssef available as a rebuttal witness if necessary.
Yes.
If a witness is not going to be called, that essentially moves the issue. On that point, Mr. Zellman, the state is not committing to calling this witness. If they do call them at that time, I will issue a ruling concerning your motion of limiting.
Yes, sir.
As to any purpose of rebuttal, ultimately what comes out as a part of the defense case, Ms. Youssef still is able to testify in that capacity. Well, the next motion of limiting concerning the testimony of Stephen Webster. Does the defense have any argument that has not already been made through great?
Stephen Webster is a lawyer. Part of the defense's motion is that he shouldn't be able to give opinions. Again, there's not a huge disagreement here.
No, Your Honor.
Ms. Kaplan, in response.
Judge, I agree with some of the defendant's motions. I don't think Mr. Webster can offer opinions. For example, his testimony, of course, will be governed by the same rules of evidence that every other witness is governed by, but he does offer some relevant points. So I think I should be permitted to, I don't know, these motions kind of blow my mind because it's like we want to pre-litigate every statement, including potentially objectionable statements that can be addressed during the trial by a proper timely objection. So I would ask that it be handled in that way.
Right, concerning the testimony of Mr. Webster and his.
And that's the first of kind of multiple times Georgia Koppelman will say, I don't even know why we're doing this, Judge. Like, obviously, I'm not going to ask inadmissible things. Like, well, if it came out at deposition, we want to make sure it's not going to come in at trial. Every lawyer and every judge is different on how much they want to try to fine tune and whittle things down. Like, this came out in a deposition, so I want to make sure it doesn't come out of trial. So I'm going to ask about it now. To me, if I'm a defense attorney, that shows what I think of the prosecutor. If I feel like I've got to do things that are obvious, maybe I don't trust the prosecutor as much or don't know the prosecutor as much. But she's like, yeah, obviously I'm not going to ask him that. And she gives appropriately in a couple different areas. So she is a bulldog, but I do think she's doing things appropriately, at least so far here. We'll see how it goes in trial with this one.
Capacity of representing the deceased certainly can testify factually as to what his involvement was with the divorce case. And also he may testify concerning the nature of the proceedings as to any opinions that go beyond that. Ultimately, I think that's where we are going to have to get into what is being asked and what would be the response that ultimately the defense would find objectionable. But generally, as to any opinion that Mr. Webster cannot give without a proper foundation, I think it's settled as a matter of evidence that no witness gets to generally opine on matters in which they are not qualified to testify to. Is any other ruling being sought concerning Mr. Webster beyond that by the defense?
Well, yes, Your Honor. In prior trials and in deposition, Mr. Webster testified about statements made to him by Mr. Markell. Those are hearsay. There's not an exception. Those statements weren't shared with anyone else, certainly not my client. Those were statements that were made during the meeting in May of 2014 that Mr. Webster.
Ms. Kaplan,
There's a couple times it cuts out as well, the volume. Somebody does this, and it's always so funny when people do this. John O'Reilly said, Wendy has not appeared as a brilliant lawyer in various appearances as a witness. On what basis do you characterize her as brilliant? All right, maybe brilliant was too far. I've read some papers that she's written that she seemed very smart. She's also an academic. She seems very smart to me. Brilliant, sure, maybe that's too far. Two smart lawyers, okay, and if you want to quibble on smart, I'll disagree with you. There, where the line is and the bar is between smart and brilliant, if you want to litigate that, fine. I don't care to. But you know, everybody's going to teach their own as they evaluate people's intelligence. But from what I've read and seen and spoken to her, she seemed like a very smart individual as well.
I think I agree in general that those statements would be hearsay. I don't recall what my theory of admissibility was in prior trials, but I would agree to approach if I intend to elicit a statement made by Mr. Markell to his attorney and offer my theory of admissibility prior to asking the question. If I decide to do that in this trial,
Bodie, you'd be correct.
I plan to do that, so it's hard for me to address what that theory might be now.
Well, again, as a general principle of evidence, hearsay that has no exception is not admissible. If the state is seeking to admit this statement for a proper purpose that actually has a basis in the rules of evidence to be admitted, you will need to approach so that way the information is not placed improperly before the jury. The motion in limine is granted as to Mr. Webster offering any opinions for which he is not qualified to give.
I mean, some of these are so obvious. He's like, motion granted, Mr. Webster cannot give opinions on things he's not qualified to give. It's like, yeah, obviously. But that's where we are.
Will reserve ruling on the issue of any statements that he may testify to by the deceased, if the state, again, will have to present an actual session to hearsay in which the matter can be placed before the jury. The renewed motion in limine concerning the Latin Kings. Mr. Zellman?
Yes, Your Honor, this goes in part to the theory of the defense and why Mrs. Adelson acted the way she did, the language that she used on the 2016 wire calls. Typically, I know that we would want to have the foundation pay through her testimony for that, but if the court were to bind our hands in questioning the state's witnesses, it would be too late to wait until she testifies.
The issue here is the defense wants to say specifically Latin Kings. The state wants to just say general gang members. The defense is like, when it gets to our case in chief, if we have Don Adelson testify and talk about the Latin Kings, it's too late. I won't be able to cross-examine people that already come up. The defense's argument makes sense to me. I don't know what the big deal is about letting them say Latin Kings versus gang members. The state wants to say gang members for sure, because that plays into their work, into their theory, but they don't want them to be able to say Latin Kings. To me, we'll see how this ends up going, but I'm with the defense on this one. We'll see if the judge agrees.
We would lose the ability to cross the state's witnesses on that issue. It's very limited. You have Luis Rivera. There will only be a few questions at most. Potentially Charlie Adelson, depending on when the state calls him. Certainly special agents. I believe it's Jimenez.
Now, in the last trial, he outright testified that he was, I guess, at least pretending or trying to influence your client as a member of the Latin Kings gang.
Yes, sir.
All right. To that end, Ms. Copperman, what is your argument?
Same as my argument has always been on this issue, Judge, which is that Rivera was a gang member. That's why he was recruited to do this. I think that's relevant. But the fact that he was a leader of a specific gang, I think is just bad character evidence that doesn't lend anything additional.
How is it bad character evidence? To say he's a gang member versus which gang he's in, why is that bad? I mean, I think the general person would be like a real gang member. That's bad character. Whether they're in one versus the other, I don't think that's more prejudicial from my perspective, at least, and how I'm looking at this. And she doesn't really make an argument to me as to why this is more prejudicial or why it's not relevant. That's Latin Kings. The defense eventually is going to respond here, and he does give somewhat of a relevance as to why that's important. And to me, this one I think should absolutely go the defense's way. We'll see if it does.
More prejudicial than probative, and I would ask to exclude those details.
Similar to what we had in the last trial, as to this painting character of Mr. Rivera specifically in a negative light, the court's ruling will remain the same. As to the witnesses, though, Mr. Jimenez or other witnesses that may present this topic unsolicited on their directs, once the horse is out of the barn, it's out of the barn. As far as in cross-examination of Mr. Rivera specifically, the defense may cross-examine Mr. Rivera as to his role as a gang member and why he was recruited into this matter to specifically serve a purpose as it relates to the conspiracy of the killing of Dan Markell. Now, with regard to undercover or the former undercover agent, this is where I believe the analysis begins to diverge on this topic.
So this is even more of an argument why they should say Latin Kings, because when you get into the undercover agent and what role he was playing and what was in his mind, and he's the one that did the bump on Donna. So we'll listen to this exchange. So right now, the judge is like, I'm going to keep it how I did it before, where you can say gang member, but not Latin Kings. We'll continue to listen to this analysis and kind of back and forth here.
First, the defendant as a Latin King member, correct?
No, sir. My recollection is, and I know that was his testimony, but I would instruct him not to say Latin King in the future. However, he didn't say anything to Ms. Adelson about being a Latin King. I guess that was his version of acting like a gang member. I don't know how well he did. Ms. Adelson didn't seem to think he did very well, but that was the intention. He did not represent himself to her verbally as a Latin King gang member. He was not wearing any clothing or other signifiers that he was a member of a specific gang. I think the idea was just, you're an associate of this killer who is a gang member.
In response on that topic, Mr. Zeldin.
Just looking at his previous testimony. My role, I'll quote from page 1067 of the trial transcript of Mr. Charlie Adelson's case. Starting at line 20, question, can you explain what that operation was? Answer, my role in the operation, I was portraying a Latin King gang member, and I was instructed to conduct the one.
So he was portraying a Latin King gang member. Now he's going to say he did not say he was a Latin King gang member, which I understand. But why is this in everybody's head here? Everybody's head that's working on the case. And I believe Rivera will say he was a Latin King member. If that's the truth, I don't understand why they're going to not like try to make it just gang member versus Latin Kings member. Now, is this the biggest deal in the world? No, I'm not saying it's the biggest deal in the world. And even if the defense win, it's like Chrome said, prosecution could use that against them. Absolutely. So it doesn't make the case like great for you if they're able to do it. I just think it is the truth. It was on people's mind. Clearly, the undercover agent had it in his mind, Latin King member. Why is that? Because that's what's going on, and that's who these people are. So I like the transparency and the truth of it. If we weren't going to bring in gang member at all, I understand that's obviously prejudicial and bad character evidence. But if we're going to bring in gang member, to me, I would just let the Latin King, and that seems like a pretty easy decision to me.
On 1068, question is, all right, when you say you were posing as a Latin King gang member, did you announce yourself as a Latin King gang member pushing your approach? I did not. Okay. So you're just, that's the role. That was my role. You're a character. That is correct. That is his testimony. And I believe that once, especially with the call that my client made to the undercover on May 6th of 2014, when he became verbally aggressive towards my client, that factors into his role as a Latin King gang member. And I know in the previous year and last year, Your Honor questioned whether there was a difference between a Latin King gang member and simply a gang member. The answer is absolutely. In Miami, in South Florida, there is absolutely a difference between a gang member and a Latin King gang member.
So that right there, while it's a good argument, I do think it opened the door to what the judge ends up deciding here. He said in South Florida, in Miami, makes a big difference if you're Latin King or just general gang member. Well, these jurors are not going to be from South Florida, but maybe some of them will, by the way. In Tallahassee, a lot of people, I was shocked how many Miami people went to Florida State and then they end up staying there for jobs of all different sorts. So it is possible that they can be from South Florida, so they may have some knowledge there. But when he made that argument, I think that kind of played on what the judge ends up deciding.
With that being said, this ultimately goes to your client's state of mind, who is going to establish how she knows the difference between, forgive the pun, the garden variety gang member and a specific gang member.
I think between her testimony and anticipated testimony of Charlie Adelson.
Did you hear that? How are we going to get in what she thinks about the Latin King? Her testimony and potentially the testimony of Charlie Adelson. So it seems pretty clear everybody thinks Charlie Adelson is going to testify in this trial, but that's not all. Seems pretty darn clear Donna Adelson is going to testify at her own trial. So buckle up, because this one's going to get real. With these prosecutors and Charlie and Donna on the stand, Donna did not testify in Charlie's case. Wendy Adelson will also be on the stand. You better believe that. This is going to be one of those trials, in my opinion.
Well, as to the questioning of the former undercover officer or special agent Jimenez, I will permit the defense to question the former special agent as to whether he was portraying a member of a specific gang as a part of his own operation.
And I think that's the right decision. When that undercover agent takes a stand, were you portraying a Latin Kings member? And if he says yes, then it's in. Okay? But the judge is not going to let them just say Latin King, Latin King, Latin King. It's going to be more gang member. Now, when it goes to Donna and Charlie, they're going to be able to talk about Latin Kings. So the judge is going to let it come out when it's appropriate and relevant, but not as a blanket. To me, I think that's better than not letting it out at all. But if you're going to let it out in that manner, to me, it's just cleaner and easier to let it out throughout the entire trial. So we got part of the way there, in my opinion.
Depending on what the answer is, we'll revisit the issue of whether the name of Latin Kings needs to be specifically uttered as to either Mrs. Adelson or Charlie Adelson testifying concerning her state of mind and knowledge of the Latin Kings. As it goes to state of mind, the defense may certainly inquire as to that during the defense case in chief. As to Luis Rivera, the court's ruling will remain the same as to his leadership role or specific affiliation. The fact that he is a gang member may be inquired into, and the fact that he has had it. Or the fact that he had, or his role while he was recruited in this case, that certainly is right for cross-examination and may be inquired into. But as to him being a specific Latin king, that is where the line is going to be drawn. Do we need clarification on these rulings?
Just one more.
Not from the state judge.
Adelson, part of her state of mind, her level of fear, is that it's not just that she learned he was Latin king, but that he was the leader of one of the branches of the Latin kings before. That heightened her fear. And of course, she will testify to that.
I cannot make her testify. If she is committed to do so as part of her defense, that's her choice. But ultimately, someone with competent knowledge has to testify to this fact. Eliciting information about state of mind from a witness that either has not spoken to your client or either has no knowledge of the state of mind, I'm not sure how that can be accomplished other than either your client herself, her son, or someone else who has direct knowledge of her state of mind at the time, unless you have an argument.
So I guess the way that we could accomplish that, Your Honor, is that Mr. Rivera, he is under defense subpoena. We would ask that he remain for the defense case so that we can call him on our case in chief.
That's fine.
So what the judge has created now is, and I think he's trying to do it the right way and the best way, which I think he is legally, and I get it. I get the decisions that he's making, but now he's created a situation where all of the information is going to come out about the Latin Kings from all these state witnesses, specifically Rivera. We're just going to have to bring him back. Trial's going to take longer. He's going to have to stay under subpoena. He's going to have to be called twice. The defense is going to have to do it during their case in chief instead of the prosecution's case in chief, which is going to go first, and it'd be much easier and cleaner. So it's like the defense is going to be able to ask their questions, but not in the order they want to. It's going to take longer. It's just like, it kind of mucks it up a little bit, in my opinion, but I get why he's doing it. Hey, Peter, thanks for covering. I know from previous podcasts, this is close to home. Absolutely. What's your take on the method of prosecution, one at a time over a long time? I don't love it. I don't love it. Not ideal. Not how I would want it to be done, but it's better than not prosecuting. It's better than not getting justice. And I think law enforcement did eventually a good job of putting this together. I think it was more difficult than it had to be, or than it should have been, really. But I appreciate what they're doing. I appreciate that they're getting justice. Even if it's slow, it's better than nothing, like I said. Why is Donna still in jail? Did they not have enough money for bail? Well, it's funny, Joanne, you bring up a good point that I did not put into my synopsis at the beginning. And the reason that she is still in jail is she's a bit of a flight risk, since, in fact, she was arrested at the airport with a one-way ticket bought by a third party to Vietnam, a non-extradition country, after Googling some non-extradition countries that she could go to flee, in fact. So those people in Florida don't get out on bond. I thought they offered Donna a deal to roll over on Wendy and she turned it down. I'd take that deal. Would you? Poll. Will Wendy ever get charged? So here's the thing. Was that deal offered? Was it floated? Was it a firm offer? Was it not? A lot of people have been talking about that on the internet, and I get to the bottom of that a little bit more and dig into a lot of the nuance on Monday's podcast. So make sure you guys subscribe and hit that reminder bell so you don't miss Monday's podcast. Off topic, but a few videos ago, you were talking about jury nullification, Massachusetts versus Brian Camp. You won't find a more perfect case. It streamed in January. Okay, I'll have to check that out. Priya, do you think the judge is doing too much? No, I really don't. I really don't. The judge has to control the courtroom and the way this goes, and I think this judge is doing that really well. Trager, Azam wanted me to say hi to Peter in the chat. You know she's had to miss the lives this week, so she'll be on Rewatch Crew this weekend. What's up, Azam? Hopefully you're here on Rewatch.
Mr. Rivera, as I recall, never had any direct communication with your client, but this is to elicit another relevant matter.
That's correct, Your Honor. It would be, once we establish the foundation, I would want to recall him for the specific purpose of him confirming that he was a leader of the Latin Kings.
Very well. Mr. Rivera will remain under the defense's subpoena until the conclusion of the trial. Let's move on to the defendant's motion of limine as to the interpretation of emails, recorded phone calls, and text messages.
This is basically like somebody can't say what somebody means in a text message or an email. We know there's a lot of code talk. There's not going to be a lot of disagreement. Of course, you can't say what they mean, but they are going to talk about code, and it's kind of obvious in some of their conversations.
Which witnesses is the defense referring to concerning this motion?
I think it goes really to retired Detective Isom, Special Agent Sanford, potentially Jason Newland. I think a number of witnesses have offered interpretation of statements that were made. Now, we're not talking about code language. Code language is treated different. What we're talking about is the emails, the recorded phone calls, and text messages, other than coded language. But we're asking the court, because it has come out so frequently, that the court prohibit the state and, the goose is the gander, the defense, from asking someone other than an expert to offer an opinion about what someone means by an email, what they meant by a statement, or what they meant in a text message, aside from the language that's used itself.
Ms. Cumberland, response?
I agree, that would not be admissible.
The motion in limine is granted as previously raised in the argument on this matter. In matters that would go to a code in which a witness could lay a proper foundation on this issue. Certainly, they may testify as to that point, but any general opining as to what an email, a phone call, or a text message means will not be permitted unless there is a proper foundation that can be laid by that witness. Next, the defendant's renewed motion in limine concerning travel as consciousness of guilt.
This is about Don Adelson fleeing and whether or not it shows conscious of guilt. Another humongous piece of evidence that if the defense could keep out, it would be amazing for them, because one of the most damning things about this case for Don Adelson is that, in fact, she was arrested at the airport with a one-way ticket out of town.
Your Honor, I know that the court previously ruled on this issue that allowed the state to use this information in their argument. The new information, as I laid out in paragraphs 4, 5, 6, and 7, I stand on the motion of those additional pieces of information had not previously been provided before. And I think that it's significant because it goes to her state of mind for making the travel and from the airport and for stepping on the job.
I'm recalling prior counsel's argument correctly, that Mr. Rashbaum did raise the fact that there was no legal process, subpoena, or warrant for your client, correct?
I believe that's correct.
Response, Ms. Cumberland?
Judge, I don't think this is new information. This was never disputed. I don't think it changes the analysis.
On this particular point, the court has reviewed the transcripts of the depositions that were cited by the renewed motion, and the ruling will remain the same on this issue as before. These matters go to the weight of the evidence and not the admissibility. The jury, as a trier of fact, is going to decide what significance to give to the evidence. The defense also is free to cross-examine on all issues that pertain to Mrs. Adelson being free to travel. The matters that have been previously raised within the motion to suppress and rule on as to phone calls and other evidence that also will be presented to the jury as well. They will make up their mind.
Thank you.
We're going to let the jury decide. It's going to be able to be presented, and they will determine whether or not it's conscious of guilt. My guess is they're going to say yes.
Well, I believe that covers the defense motions. And Ms. Cumberland, you stated that the state did not have an additional motion in limine that not been previously voted on.
That's correct, Your Honor.
Judge, there's one additional one also filed on July 21st concerning the opinion testimony of Jason Nolan and Patrick Sanford.
Oh, yes. Go ahead with that motion.
I'm sorry, Your Honor. I'll stand on the motion.
Ms. Cumberland, response?
Judge, the defense elicited personal opinions of these witnesses at deposition about.
This is where Georgia Koppelman takes a shot at the defense attorney like, you asked these questions to Depo, not me. I would never ask these questions. We all know they're inadmissible. I don't know why you asked them, just to say no objection at the end. This is where she takes a shot, and some people that might not like her demeanor might not like this, but she's going to take the shot, and she's like, I don't care. Go ahead and grant this, Judge. I'm a real lawyer. I know I can't ask these questions.
The lawyers and their ethics and how they think they might have been involved in the new investigation, and now seeks to suppress those opinions, which are clearly inadmissible. I don't understand it. I don't know why we're doing it. I would never elicit such a thing.
Well, Ms. Cumberland, even though it might be inquired into in deposition, ultimately, if there's a basis to exclude it in trial, that's why it's being raised now.
Of course, there was no reason to elicit it at deposition, and it could never be admissible at a trial. So we're just wasting paper and time. These motions. No objection.
The state is conceding the issue. The motion is granted as to any opinions that would be offered by an investigator Newman or Special Agent Sanford. Again, there must be a proper foundation for them to offer an opinion on a subject. If they don't have the ability to do so, it cannot be presented as a part of the case in chief. I don't really see a context in which this might come around, either in rebuttal or as far as impeachment. But again, these rulings are being made as to states, the substantive evidence the state may present as a part of its case in chief.
He's like, listen, the defense is just trying to make sure everybody's on the same page about what evidence is and is not coming out at trial.
to be readdressed as a matter of either impeachment or rebuttal, we'll take it up at the appropriate time. All right, let's go ahead and talk through some of the logistics for jury selection on 8/19. We are going to be in this courtroom once again. I believe the number of jurors that we have under summons right now, the respective jurors under summons, I believe it's near 300. So what we're going to do on that
300 jurors. That's a lot of jurors in Florida.
Tuesday,
There was a motion filed to change venue. Judge denied it. But if they're not able to pick a jury, then there's still a chance they could change the venue. But I will also say there's been multiple trials in this entire Markel Adelson saga, and they've been able to pick a jury every single time. I think Georgia Copland says it's only ever taken them 2 or 3 days to pick a jury. So again, far from impossible. Don't need to change the venue. We're going to be able to pick a jury. So when's her trial date? They're about to talk about it right now. Jury selection is going to start August 19th. That's a Tuesday, which is like perfect for me because I have a trial starting August 18th. That's going to be done by Friday. So I'm hoping they take most of that week for jury selection, and it's easier for me to cover the case than having to like watch everything at night while I'm also prepping for trial. That might be impossible. We'll see. But very, very interesting. Starts August 19th with jury selection, which will take a couple days.
essentially, we will have the pre-screen of jurors on the issue of pretrial publicity, similar to what we did in the last trial. The court will be asking these same questions, or substantially the same questions. Both parties will have an opportunity to follow up on the court's questions on the issue of pretrial publicity. If a prospective juror is deemed suitable to return for a group venue, from there, they will be given a date and time for which group venue will begin. For the pre-screening that will take place on both Tuesday morning, Tuesday afternoon, potentially Wednesday morning and Wednesday afternoon, I would anticipate by that point we would have a suitable pool of jurors from which, going through the pre-screening process, anyone who has had an issue or either the court believes, the state believes, or the defense believes is not suitable to go to the group venue. From there, each party will have an opportunity to make their objections known as to that respective juror, and either they'll be told to return or they will be excused at that point. Does anyone have a question about the pre-screening process?
No, sir.
There you are. Also, as well, so that we don't have any issues similar to what occurred in the previous trial, in which I believe there were allegations the jurors were speaking to each other. We are going to have additional bailiffs. The prospective jurors are going to be instructed not to speak to each other. It might make a long day for them, but they will be sitting in silence. We will provide reading material to them, and we'll have extra bailiffs on hand to ensure that no one is speaking to each other while they're waiting to be screened. Does anyone have anything they need to raise concerning those?
Is it your Honor's intention to handle the pre-screening, I don't know what it's called, instructions that happen down in jury assembly?
Yes. I believe last time, I'm not sure if someone else qualified or not, but for each group that will be qualified, I will do it personally, so that way from beginning to end, they are seeing me, hearing me, and understanding you're not to discuss the case or anything else with each other.
Perfect, that's the state's request.
Judge, how many of the 300 are coming each day?
Broken up into groups of 50, so 50 in the morning, 50 in the afternoon. We may not even need to get to.
Just for reference, like in most of my trials, we have like 35, and sometimes that can take all day. In a civil trial where nobody even knows anybody, in a criminal trial, usually they go a little bit faster. Even for us, judges are a little tighter on what you can do in jury selection. So 50 in the morning, 50 in the afternoon, it's going to be brutal. It's going to be a grind. Oof, she might regret the decision to testify, remembering how that was such a bad decision for Alex Murdaugh, but I can't wait to see what she says. Yeah, I mean, I thought Charlie Adelson did a pretty decent job, almost too good of a job when he testified, so we'll see. Can Charlie Adelson plead the fifth due to ongoing appeals if he testifies? Hope you have a great weekend, Peter. So unless there's some kind of deal with the state or something that I don't know, yes, there are certain things that he can plead the fifth to. They have his statements in the trial already as well. So there's kind of a number of different ways to get those statements in. We'll see what ends up happening. But he still has a Fifth Amendment right because it's on appeal. Why are they not calling her husband? He had to know what was going on. They make these strategic decisions. They didn't call Donna or Harvey in Charlie's case, and they still won because they have recordings, they have text messages, they have the family law documents. You kind of pick and choose as a lawyer strategically who you want to call. PMD, would you ever break a story like Tim did on STS, even knowing there's a high chance it's BS? I try not to be a reporter or a journalist, right? I'm a lawyer. I try to break down things. I really don't try to break stories. I have gotten information before, I'll just say, from good sources. Like just today, I was talking to somebody that I have stuff I could break. I just don't feel like that's my job or my role here on YouTube. I feel like it's breaking down the cases, answering your questions, learning about the judicial system, trying to make everybody a better part of society, better jurors, better plaintiffs, victims, defendants, just like understanding this process better for everybody that it may touch in the world. So that's what I try to stick to. But if you'd like to hear him explain himself, you might get that opportunity. How many trials have there been already? Charlie and who else? Charlie, Catherine McBanawa twice. And then I think Sigfredo Garcia, I think, went to trial and was a quick verdict. Luis Rivera is the other guy, I'm pretty sure. He pled. So I think there's been 4. This would be the 5th trial, I'm pretty sure. But I came in kind of at the tail end of Catherine McBanawa when I actually started covering it because I was not going to cover it, didn't want to cover it because of just kind of my connection to things. Some stuff happened in the background, ended up making me want to cover it. So that's what happened. Peter, can you repeat the judge's rulings when he gives them, as it's difficult for some of us to hear? Yes, the big ones I will absolutely repeat. Family law file, a lot of it's going to come in. Some of it might not. Consciousness of guilt, her fleeing is going to come in. Those are the 2 biggest ones at this point. And then if you've missed some shots taken by Georgia Koppelman, she's like, we're just wasting paper with these motions, Judge.
The end of this grouping altogether, if we were able to go through the pre-screening process on the issue of pretrial publicity. Once we have, say, 100 to 110, that's more than enough to get 12 people.
How do you intend to handle proceeding once we successfully select a jury?
Once we have selected a jury at that point, and also I believe too, we'll need at least 2 alternates unless the parties wish to have 3.
That's a request for your honor.
But once we have our 12 jurors and 3 alternates, at that point, we will swear them. If we have enough time to actually move into opening on that same day of the selection, we'll do that, so that way we can start to begin into witness testimony seamlessly without issue. How many days is the state anticipating to go through its case in chief?
I think best case scenario is 5, worst 7. So 6. I could see how it could run into the first part of the 7th day, Judge. I think 6 is a comfortable estimate.
Now we're going to start to try to understand how long this trial is going to take, right? Assuming they have a couple days for jury selection, the state says they have 5 or 6 days, and then we're going to hear from the defense. So we're going to know overall 2 to 3 weeks is what this trial feels like starting August 19th. So about 2 to 3 weeks from there is overall what it's going to feel like. We'll hear them kind of explain why here. When does it ever go well when a criminal defendant testifies at trial? So it can go well, right? It really can. An example of somebody who I think did help his case, and again, some people are going to hate this and whatever. I'm just going to say from my perspective, I think it was really important in him getting a not guilty verdict was Rittenhouse when he testified to what he was perceiving and what he went through. And then they were able to use the expert that could only testify building on what Rittenhouse said he saw in the reaction time, et cetera, et cetera. I thought that was important. It does go well from time to time, especially in self-defense cases. But most of the time it does not go well. This is a good point, Susan. Thank you. Peter, Laura, sent me a Facebook friend request, wanted to make sure it was you. None of your posts showed that I had liked them. So it was sus. This is not me. Report this person on Facebook if you are requested to follow or become friends with them or whatever. It is not me. Somebody created one and it is what it is.
Assuming that we have a jury by Friday the 22nd, and know that in place August 25th through September 2nd as the state's case in chief. But then there's a holiday on September 1st, correct?
Yes, sir.
Is anyone long-term work on Labor Day?
Jackie is.
I mean, one other kind of unrelated next side of the table.
And yeah, we also have the holiday in the middle of this trial as well.
It is a holiday for the workers of the world, but we cannot forget that we have a trial to finish. All right, 8:25 through 9:02, then we're estimating as the state's case in chief. How long is the defense estimating to present any case that it wishes to do so?
Can I weigh in on that before they speak, Judge? We have historically put the jury in 3 days at the longest. Twice we did it in 2 days. So my suggestion would be to start on Friday. We could even do
Yeah, she's like, it's only ever taken us 2 or 3 days, Judge. So I don't think we need to plan on this taking 2 weeks.
openings as early as Thursday, if your honor was willing to entertain. I know that's not.
But the defense's position is we don't think we're going to be able to pick a fair jury here at all. So you can expect the defense doing everything they can to strike every single juror that knows anything about this case, and it's going to be negative for Donna Adelson, and she needs to get out of this county in order to get a fair trial.
Defense's request, but that would be the state's request, just to move it on as quickly as possible.
Well, for openings only, does the defense have a position concerning this?
We don't want to make openings unless we have a great deal of time after we pick the jury on a particular day. We would prefer to do the openings the next day.
Yeah, I agree with that. You're in such a different mindset during jury selection and picking a jury. I like to go home, sleep, wake up in the morning, start with openings. And when openings are only going to be 30 or 45 minutes, it's not saving you that much time doing them the day before. You get up in the morning, the first hour, hour and a half, from 8:30 to 10 or 9 to 10, 10:30, something like that. And then you get your first witness on still in the morning. I always push for that until I try to make it like, Judge, we need to do that. We need to do that. Unless we're almost done picking the jury the night before and we get there early in the morning just to finish and swear the jury in. Then, of course, we can do openings after that. So I agree with the defense here. And I think that's what should happen in this case. We'll see how the jury selection process goes.
So you're not asking to defer the opening to your case, you just don't want to open on the same day,
It's going to depend, Judge, on your ruling on any additional motion.
right? On that matter, again, depending on where we're at time-wise, I'll just instruct both parties to be prepared to potentially give their openings. I'm not going to place a time limit on the opening statements, but obviously, each party will be the captain of its own ship as to how you'll captivate the jurors. Is either party expecting their opening to go beyond 30 minutes?
Depends on your ruling, Judge.
Ms. Calvin?
Yes, I think it could be up to 45 minutes. It's not going to be different than it was previously, but I'm sorry, I don't know how long it was. I would say 30 to 45 is comfortable range, Judge.
Well, as to the defense case, once we are finished with the state's case, how much time are you estimating?
Depends on your ruling, Judge, but anywhere between 4 and 6 days.
4 and 6 days. So that would place us then around the week of September 8th. Concerning any other matters that we can address as the logistics of the trial, I believe we will have rooms available for our family members, both for the victim's family and for the defendant, to always anticipate making use of these rooms.
Yes, Your Honor.
Yes, sir.
Right. Please contact court administration. From there, you'll receive information as to how to access the rooms, and then they will be made available.
Judge, can I clarify your intentions about when to start testimony?
Go ahead.
You intend to start testimony on the 25th, is that right? With the possibility of openings having already been conducted?
Well, at the latest, if we go into Friday, we need to select a jury.
Okay. If we get a jury,
If we get a jury prior to that Friday, on say the 21st, well, at that point, there's nothing preventing the testimony from getting started on the 22nd.
okay, so I'll be prepared to start testimony on the 22nd then. And my understanding was, and my subpoenas run through September 5th, but it sounds like we might be extending into the week of September 8th, is that right?
Well, I believe the defense is indicating they might need anywhere from 4 to 6 days.
That's what they said. All right, so we could potentially go through the week of 8th.
If need be.
All right, I will attempt to get subpoenas out for rebuttal for that week, but I will advise the court that as of right now, those are not available.
We are losing a day because of September 1.
So it seems like she thought it was going to end a little sooner than what the judge's scheduling kind of looks like at this point. Heather said, I just got called for federal jury duty in Eastern District of Pennsylvania. I can't tell you how excited I am. I love to hear that, Heather. And that's really been a change of mindset, at least for the people in this chat, in this community, that have come and followed along and learned so much and given me so much and taught me so much about what they think and helped me learn how to talk to a jury and even a judge, whoever my audience is, that is the fact finder I'm trying to prove cases to at my trials. So I absolutely love it. I love the way it's changing the jury system, making people go in open-minded, being better jurors, make it easier in these cases to pick jurors and to pick juries. And that's really important in going and following the law, listening to the facts, listening to the judge, knowing what the roles of the judge and the lawyers are and how everything works. I absolutely love to hear it, Heather. And I hope you get picked. Golden Temple Light, Depp was great on stand. Yeah, that's a civil trial. Civil trials, whether you like it or not, the defendant and the plaintiff almost always testify. So very different than in a criminal case. You can't say, I'm good, I don't want to testify. Can't do that in a civil case. How do lawyers estimate the length of cases? Do they have their witness prep done before trial? If not, how would they know how long they might take? So in this case, it's easy because they've already tried this case multiple times. But generally speaking, that's exactly what we do. We have an order of proof, we call it. Here are the witnesses we want to call. What order do we want to call them in? How long do we want to be with this witness? Because sometimes you can go longer or shorter with the witness, but you plan. Keep it simple, stupid, right? We want to pare it down. We only want to give the jury what's the most important thing, and the point of the testimony. You want it to be obvious to the juror. Get them up, get them down as quickly as you can to make them as effective as they can possibly be. So we know our openings are going to be 30 to 45 minutes. We're going to do these 3 witnesses that are going to be an hour each. Cross is probably going to be 15, 20 minutes. These 3 witnesses are going to be quick, 10 minutes with 5 minutes of cross. Then we get to day 2 and we've got an expert and they're going to take half a day and we got to block a half a day and pay him for the expert. So that's exactly how we do it. And a lot of times we'll tell our expert, you're going to be called either Tuesday afternoon or Wednesday morning, things like that, because we can really plan ahead. I always build in extra time because I don't want the judge to be pissed at me if I take a half a day longer than I'm supposed to, but everybody's happy if I'm a half a day shorter than I thought. So you always want to make sure it's built in there. And it's really important if you're like 3.5 or 4 day trial, I always just say 5. Judge, let's block the whole week. Tell the jury it's going to be the whole week. If you're going into day 6 or 7, it's like we got to block 2 weeks now. So let's make sure we have enough days. So, that's really important. If it's only gonna be a 1-day trial or 2-day trial or something like that, you want to tell the jurors because you have the opportunity to pick more jurors can sit around for 1 or 2 days than may be able to stick around for 5, 10, 20 days of trial. So yes, you can plan it out pretty good if you know your case and you're prepared ahead of time. Apparently Donna Adelson has money in Vietnam. She's Ho Chi Minted. Zing.
But if need be, we can figure out logistically how to make this work for Saturday, continue working. I'm sure you all would like a break, but I'm here. A lot of times it matters of logistics that need to be raised, considering
Hey, Judge, we're gonna have an issue regarding space. We're not all gonna fit here.
So this is interesting to me. She starts talking about space and the issues, and this is where cameras in the courtroom are important. Neither of these lawyers were at the FACDL seminar I was at, but we did talk a little bit about this and positioning and what the cameras pick up and don't pick up. And I think she makes a very smart point. This lawyer is a former judge. She makes a very intelligent point as to we've got to make sure that Donna Adelson's rights are protected because there are going to be cameras in here, which we get it, and that's how it's going to be. But we have some concerns. Let's listen to her concerns and see how they're going to figure it out. And remember this when we see what the courtroom looks like when the trial starts, because I don't think it's going to look like it does right here.
We also don't want our computer screens facing cameras and the audience being able to see what's on our computer screens. I have become very old, and the font size I use is very large, and probably someone in the back row can see what I have on my computer. So we're going to need to have, I understand we're blocked by this column,
right.
but we're going to need to have some kind of setup where we can put our things and our defense not be disclosed ahead of time to the media and blogs and this and that. The second thing is these microphones used to have the ability that you could touch it and it would turn off. My client is hard of hearing, so she talks loud. So everything she says is going to be picked up. This one is now set up so you have to press it each time you want to mute it. And like press and hold, you got to hold it down for it to continue to stay muted. And we're going to ask if the court admin could put it back to the function where we can push it off. I don't think there's going to be any opportunity in the trial for someone to not pick up on a recording of Mr. Zellman's voice. He's very loud. I tend to be loud too. So it's not going to be a record issue in our position, but it's certainly going to be a problem when we're trying to speak to our client about something because it's going to be heard.
Well, in front of the jury, but I understand the concern that we're registering with this. It implies that can be done from a microphone on the table. If your client does need to write things down, so that way nothing's being given away, that might be the easiest way for that to be handled, but that requires the microphone. The seating set up in the gallery, I believe the first 2 rows behind the defense, those are not going to be available to any members of the media. As far as the font size of your computer, if you need to rearrange how you're going to seat at the table, so if you need a seat on the far left, or my right, your left, so that way your computer can face the wall and no one can see it. I don't really know what I can accommodate you with as far as that font size beyond that.
Well, the problem at the end of the table is it's not open. It's the leg of the table. So I don't know if you can add a little something, another table that is the same size.
What I've tried a 3 co-defendant first-degree murder trial in this room before, and what we had done was one table was between the column and the bailiff's box. There was a table here, and then this table here. think that if we could put a table to our left, that might be one way of accommodating this.
Right. If you make a request, you have to adamantly to figure out the best way to try to configure the tables. Ultimately, for what needs to come in with, I believe the state is going to try to, well, needs to bring in its equipment, audio equipment.
Yes, Your Honor.
Because of that equipment and how it need to be set up, the tables and how they're configured can't interfere with that, and we'll try to accommodate that as best as possible. It's kind of as to the audio visual needs of the state, other than what has been used before with the audio setup, is there anything that needs to be addressed?
No, sir, with the same setup, with the same company.
So, right. Probably
I foresee them setting up the courtroom in a different way so that the cameras aren't picking up anything on their table and can't hear anything on their table, and fixing the mics, because that's all very sensitive to the client confidentiality. We talked a lot about this. I said the lawyers are very worried about this, as they should be. I pointed it out to anybody that has a high profile case to do exactly this. Make sure people can't see anything on the screens. We know that's been a problem in the past. Make sure they can't hear anything in the high sensitivity mics. And there's really no argument that the public has, or that the media has, on that, because even the court's access and the public's rights and interest in the case, they're to go and watch the case and see what happens and see the judge and hear the lawyers argue and see the witness testimony, not to hear and see what's happening exactly at counsel table, private documents, private conversations. So you will never lose that argument, but you have to ask for it sometimes, and you have to bring it to the court's attention so that if it happens, it nips it in the bud. And so nobody is taking measures to actually do something like that. It's horrible to try and like take a picture or do something to over the lawyer's shoulder. Just because you can see it doesn't mean you should look at it, or listening in to a conversation between the lawyer and the client. So again, be careful with the privileges that we're given, right? And don't bite the hand that feeds you. Act appropriately, act respectfully, and we'll still be getting to watch and learn from these trials.
then they'll need to get started by the 15th in this room, so they can set up all equipment, test the equipment, and if there's any problems, we'll be able to figure out what needs to take place before we actually get started on the 19th. All right. For the media presence that would be here as well, I believe it would be some of the rules as it's been in the past. There will be one live video camera, there will be one still frame camera. Obviously, the bloggers and reporters, they are permitted to take notes as if they were print journalists. Then the initial rows behind the state, as Captain, I assume the victim's family is wishing to appear.
Yes, Your Honor.
They will receive priority seating with regard to how they're positioned in the gallery. After that, it will be free to the public and press to seat in all areas that are available. Does other party need to be heard concerning those?
Your Honor, we're also going to need space for our client's family and friends who are going to be coming to support her as well. We would request that they have similar priority seating as the victim's family.
That's what the 2 rows will be behind the defense that will be available to family and friends. Again, similar to last trial, other than the video recording and still frame photography recording, beyond that, no cell phones are to be out recording any other matters, or trying to take photos of the witnesses or the jurors. I believe similar in the last trial, when Special Agent Jimenez testified, his face was not shown, obviously because of the nature of his past work. The court will just make the same ruling concerning that as well. His face is not to be shown, but of course, the substance of his testimony certainly may be reported on by anyone who believes it is newsworthy. During the selection of the jury, the faces of the respective jurors are not to be shown, their names are not to be shared. But as far as any biographical type data, such as the composition of the jury, being, for example, 7 male, 5 female, what their professions are, those are certainly able to be reported on by the members of the media and disseminated, but ultimately what we're talking about getting at is names and faces, so we don't have any disruption or disturbance during the trial. Do any of the parties have any questions concerning those?
No, Your Honor.
Your Honor. One last thing, typically, I don't think I've had a trial with you quite some time. Typically, my paralegal.
So no difference there, protecting the juries, but they all are going to be able to say 5 women, 7 men, whatever it ends up being. And then he's like, we have a lot of people coming to help us judge. My paralegal seems like they're going to have a big group there on the defense team. What will that look like to the jury? What do you think if you were a juror and you're looking over at defense table and there's 7 people there sitting there, Don Adelson and 6 other people working for? Is that a good thing? Is that a bad thing? If the prosecutors only have 2 or 3, what are you thinking about that as a juror? Because that is something criminal defense lawyers think about. What are the optics there? Sometimes we overthink certain things. Sometimes jurors are like, whatever, we don't care. Sometimes they're like, oh, that's really good. All these people fighting for her. Or they're like, oh, that's really bad. Why does she need so many people? The prosecutors only have 2. What do you guys think? Let me know in the chat.
Sits with us, so that's another reason why we need that additional table. She also may have some additional people assisting her, and I'll make sure that they're identified as the bailiffs so that there are no issues there.
Members of the direct support staffs may sit on the benches that are behind the attorneys, or if you need to figure out a table configuration for them if we have the space. But the direct support staff is permitted as to both sides. Does either party have anything further to raise concerning the logistics of the trial or any other issues before we finish?
No, Your Honor.
There you are.
One other matter comes to mind.
All right. So that's it from the hearing. I've got a couple questions I want to answer here. Sorry if my jokes are too much. I'll stop. The real Melon, Lord, they don't bother me. It's just sometimes when I don't know what a comment is and I'm reading it, I just got to be careful about making sure people don't think it's my joke. Maria, Peter, if we get a jury notice, do we disclose that we watch the lawyers on YouTube? If they ask, it's something that I've put into my jury selection. It's something that I have consulted, if you want to call it that, on people that have asked me when dealing with high profile cases, what might work, what might not, what you can learn from certain things if they follow certain people. I think all of that is incredibly important in jury selection, and I'll probably do more on that, helping lawyers deal with jury selection and deal with kind of new media. But if they ask, absolutely tell them everybody you listen to, but I don't think it's something you have to bring up. If they ask, are you into true crime? What podcast do you listen to? Anything that it's a truthful answer to, absolutely tell them. Peter, did I hear that right? 12 jurors and 3 alternates? Yes, I believe that's what they said. I think because they started with 2 alternates. I think they got to 3. I'm not sure. Numbers. YNW Melly trial pushed to January of 2027. I didn't see that, but that is brutal. Eventually we'll get there. We will be covering that one. That'll be really interesting to see how that goes. 2 of the lawyers were in the Florida Association of Criminal Defense Lawyer meeting that I spoke at and came up and talked to me after about that case. So that one I'm really interested in. Okay, that's it. We are coming up on this trial. If you guys are following it, let me know in the comment section. Please take a second and hit that like button if you guys have not already, so that whoever wants to follow this trial will come here, hang out with us, tell us their thoughts on it so we can learn from them. They can learn from us. That's all we got. Till next time, stick around here for the new outro. I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.